పెట్టారు. వాళ్ళు పెట్టడం వల్ల నేను ఇక్కడికి వచ్చి చెకప్ చేయించుకున్నాను. షుగర్ టెస్టింగ్ మిషన్ కూడా ఫ్రీగా ఇచ్చారు.
హెల్త్ క్యాంప్స్ మేము స్టార్ట్ చేసే ముందు అందరూ హెల్త్ క్యాంప్స్ చేస్తున్నారు. ఇప్పుడు అది మంచిది.
తెలుగు వారికి అనుకోని ప్రమాదాలు సంభవించిన, జరగరానిది జరిగి మృత్యువుతో పోరాడుతున్న వెంటనే నాట్స్ అప్రమత్తమవుతుంది. బాధితులకు కొండంత అండగా నిలబడుతోంది. అవెనెల్ అగ్ని ప్రమాదంలో సర్వం కోల్పోయిన తెలుగు వారిని ఆదుకుంది. బేబీ హర్షిత, అర్చనా సిస్టర్స్, లక్ష్మణ్ దూసా, అభినయ్ రెడ్డి, గోపి లింగంగుట్ల, సాయి దొండపాటి, విష్ణు పుప్పాల, మధు మాదల, ఇలా చెప్పుకుంటూ పోతే ఎందరో బాధిత కుటుంబాలకు నాట్స్ ఆర్థికంగా అండగా నిలిచింది.
అందరికీ నా ధన్యవాదములు. ఈ మనీని నా పిల్లల ఎడ్యుకేషన్కి మంచిగా యూస్ చేస్తానని ప్రామిస్ చేస్తున్నాను.
ఇండియా తెలుగు వాళ్ళు అమెరికాలో ఉన్నట్లు కాదు, మేము అమెరికా తెలుగు వాళ్ళం. మేము డిఫరెంట్. మేము మీకంటే ముందున్నాము సహాయం చేయటంలో. మీకంటే మాకు గొప్ప హృదయం ఉంది అని చెప్పడానికి కోసం నాట్స్ చాలా కృషి చేస్తుంది.
ప్రమాదవశాత్తు తెలుగువారు ప్రాణాలు కోల్పోతే అలాంటి వారి పార్థివ దేహాలను మాతృభూమికి తరలించేందుకు కృషి చేస్తోంది. తెలుగువారికి సాయమే కాదు, వారి కోసం సమరం చేయడంలో కూడా నాట్స్ది ముందడుగే. ట్రై వ్యాలీ, హెర్కున్ యూనివర్సిటీల్లో తెలుగు విద్యార్థులకు జరిగిన అన్యాయాన్ని ప్రతిఘటించింది, వారి తరఫున పోరాడింది.
నాట్స్ గురించి తెలిసిన తర్వాత వీళ్ళ గురించి కొంచెం రీసెర్చ్ చేస్తే తెలిసి వచ్చింది. ఉన్న వాటిలో వన్ ఆఫ్ ద మోస్ట్ జెన్యూన్ ఆర్గనైజేషన్స్గా పేరు తెచ్చుకున్నారు.
భాషే రమ్యమని నినదించే నాట్స్ తెలుగు భాషకు ఇంటర్నెట్లో NTR, నాట్స్ అనే 2 యూనికోడ్ ఫాంట్లను రూపొందించి తెలుగు జాతికి అంకితం చేసింది. తెలుగు జాతి ప్రత్యేకతలను, తెలుగు ప్రముఖులను ప్రతి నెలా పరిచయం చేస్తూ అక్షర దీపికతో అమ్మ భాషకు అక్షరాభిషేకం చేస్తోంది. ఇమిగ్రేషన్, హెల్త్, వెల్త్ సంబంధిత అంశాల్లో సదస్సులతో నాట్స్ తెలుగు వారికి అవగాహన కల్పిస్తోంది. వ్యక్తిత్వ వికాస సదస్సులతో తెలుగు యువతలో స్ఫూర్తిని నింపుతోంది. అమెరికాలో తీయటి తెలుగు పాటల ప్రవాహం ఈటీవీ పాడుతా తీయగాను దిగ్విజయంగా నిర్వహించడానికి నాట్స్ తన పూర్తి మద్దతు అందించింది. అమెరికా తెలుగు సంఘాల చరిత్రలో తొలిసారిగా తెలుగు నేల నుంచి వచ్చే విద్యార్థుల కోసం నాట్స్ బీమా పథకాన్ని ప్రవేశపెట్టింది.
తెలుగు విద్యార్థుల కోసం ప్రవేశపెట్టిన నాట్స్ లైఫ్ ఇన్సూరెన్స్ పాలసీ నా జీవితంలో మర్చిపోలేనిది. నేను చైర్మన్గా ఉన్న సమయంలో ఇలాంటి పథకాన్ని తీసుకురావడం నా అదృష్టంగానే భావిస్తున్నాను.
ప్రతి ఏటా 1 మిలియన్ ఫుడ్ క్యాన్ డ్రైవ్ పేరుతో నాట్స్ అన్నార్తుల ఆకలి తీర్చే ప్రయత్నం చేస్తోంది. జన్మభూమి రుణం కొంత తీర్చుకోవాలనే తపనతో నాట్స్ తెలుగునాట శ్రీకాకుళం జిల్లా ఉద్దానం కిడ్నీ బాధితుల కోసం ROC ప్లాంట్లు ఏర్పాటు చేసింది. అనాథ పిల్లలకు అండగా నిలిచే చిన్మయ విజయ, బ్రైట్ లైఫ్ ఫౌండేషన్స్ కు నాట్స్ తన ఆర్థిక మద్దతు అందిస్తోంది. చిత్తూరు జిల్లాలో సేవా వృద్ధాశ్రమానికి సాయం చేస్తోంది. తెలుగునాట వరదలు, విపత్తులు సంభవిస్తే బాధితులకు మేమున్నామని ఎప్పుడూ ముందడుగు వేస్తూనే ఉంది. తెలుగు రాష్ట్రాల్లో ప్రభుత్వ బడులకు అండగా నిలవాలనే సంకల్పంతో పాఠశాల దత్తత కార్యక్రమాన్ని నాట్స్ చేపట్టింది. దత్తత తీసుకున్న పాఠశాలల్లో మౌలిక సదుపాయాల కల్పన, పుస్తకాలు, బెంచీలు, విద్యార్థులకు స్కూల్ బ్యాగులు అందించింది. డిజిటల్ లైబ్రరీలు, డిజిటల్ తరగతి గదులు ఏర్పాటు చేస్తోంది.
జన్మభూమి రుణం కొంతైనా తీర్చుకోవాలనే తపన నాకు అమెరికా వచ్చినప్పటి నుంచి ఉండేది. అక్కడ ప్రభుత్వ పాఠశాలలో పిల్లలకి పుస్తకాలు అందజేసినప్పుడు, అలానే డిజిటల్ తరగతులు ఏర్పాటు చేసినప్పుడు ఆ పిల్లల కళ్ళల్లో చూసిన ఆనందాన్ని నేను ఎప్పటికీ మర్చిపోలేను.
శిథిలమవుతున్న ఆలయాలకు కొత్త వెలుగు ఇచ్చేందుకు నాట్స్ సేవ్ టెంపుల్ ఆర్గనైజేషన్తో కలిసి అడుగులు వేస్తోంది. రమణ మహర్షి అంధ విద్యార్థుల పాఠశాలకు ₹1 కోటి విరాళమిచ్చి అండగా నిలిచింది. పోలియో బాధితులకు చేయూతనిచ్చేందుకు విజయవాడ రోటరీ క్లబ్తో కలిసి పనిచేస్తోంది. బాలల సంబరాలు, యువ సంబరాలు, క్రీడా సంబరాలు, మహిళా సంబరాలు, తెలుగు సంబరాలు, ఇలా ఏ సంబరమైన నాట్.
On immigration, we have our team members from NATS. Myself, Sunil, I'm the board member, and we have several folks from our NATS Houston chapter. We have Hemant Kola, who is our Houston chapter originator, as in he's the one who started the chapter with his contacts in the national NATS organization. He has been helpful, to put a foundation for the NATS organization. And we have other founding members, myself and Srinivas Kakumanu, who are part of the NATS central team right now. They're serving in various roles. And also we have our current NATS Houston chapter coordinator, Viru Kankatla, along with Vijay Dontaraju, who is our joint chapter coordinator of Houston. So today, Vijay and myself will be moderating this event, discussing the questions everybody has, on the current immigration situation in USA. Yeah, thank you for everybody who joined. I will hand over to Vijay, to discuss the next part of the webinar.
Yes, Sunil. Thank you very much. Thank you everyone for watching NATS created event here. Thank you for joining. So last couple of months, y'all know that it's pretty roller coaster ride for the immigration, and pretty much go to any immigration, pretty much any events that immigration has been the main topic that has been talked over. Two people standing together at a party or talking about either GC, priority date movements, or the new H1B restrictions that are coming towards us. I think there are a couple of rules that are proposed on H1B, as well as there is significant priority date movement that happened in November 2020 visa bulletin. So that basically created a good amount of movement and people talking about their upgrades and downgrades. So this brought us into this context about, okay, this is a pretty complicated environment right now, so we want to introduce everybody to one of the experts in Houston community here, Uma Garu. So Uma Garu, she runs a law firm, Mantra Law Office, based out of Houston, founded in 1994. As you all know, immigration is pretty complex topic, and it's pretty complex, also intimidating sometimes. It's not always it's always a good idea to go with an expert opinion, and thanks to the NATS national team, we were able to do this webinar here, bringing together an expert and someone from an industry and the entire panel, so that we can discuss these different questions and the ideas that are coming out of the community here. And Uma Garu, she runs a full service immigration law firm, and with I think their law firm stands out by giving personalized and prompt and professional services for the immigration community in Houston. So without much ado, I want to give the mic over to Uma Garu for an introduction, and she will introduce.
Thank you so much. Good evening, everyone. And special thanks to the entire executive board of NATS for conducting this webinar at a time, like you rightly pointed out, when everybody's going through the rocky road of immigration issues. Day in and day out, every day we see by the hour, there are changes that keep coming every day, literally. And each one of us hoping that morning we will see some good news, but nothing that is satisfying to our minds. However, given whatever situation we have, coming from the South Asian background, Indians, we've always been told to take the best out of what we have. So, given the situation that we have, we as attorneys also try to advise everyone in the community to avail what is available to you at the moment, because we cannot predict what's going to happen in the future. So having said that, let's start with the October Visa Bulletin, which had created quite a turmoil in the community, especially I call it the IT and the H1B community. And a lot of people were unsure, should I be filing? Should I not be filing? Should I be downgrading? Should I not be downgrading? Should I be in the EB2 line? Or should I be in the EB3 line? Which line do you think is going to go forward? Believe me, I probably got hundreds and hundreds of calls asking me this question repeatedly. Should I stay in lane 2 or lane 3, which is EB2 lane or EB3? I just put it that way. But none of us know which lane is going to move forward. It's like being on a freeway. If you're in lane 2 and you see lane 2 is blocked, and suddenly lane 3 is opened up, you jump into lane 3. Then you find actually lane 2, which you were originally in, is moving further. That's sometimes providence of life. But I'm not saying we compare driving on a freeway to EB2 and 3. It was just a simile or an example, how life is all about. But having said, go ahead.
Absolutely. I mean, wish we had a magic wand or a silver bullet to answer all these questions, right?
Right.
It's not that easy. So go ahead. Sorry, I might have.
No problem. I was just going through, we've all gone through, or a lot of people have gone through, whether to downgrade or not, whether to, if they decided to go to the EB3 route, there was also questions, do I amend or do I file a new petition? And there's been so many rumors. If you amend, it's better. If you file a new petition, it's better. I do have the PowerPoint presentation which talks about it in comparison when you amend versus filing a new I-140 petition. I'm not going to go into detail about this because a lot of people know about it, but I'm just going to touch the topic about it, whether one should amend or whether one should file a new petition. You may say, why are we talking about this? We've discussed this also in October, and October is almost coming to an end. The November bulletin is out, and the November bulletin is almost a mirror image of the October bulletin. There's not much of a change in it. Pretty much the final action dates and the filing dates have remained the same for EB2 and EB3. So even though they've remained the same, there are a number of people, as I've mentioned to you, who were still contemplating to do or not to do. So they were in that situation. And some of them had the issues where they did not have the support or, the employer was not willing to file the amendments for them. So having been in that situation, they could not rush and file it. And now that the November bulletin is out and the USCIS has indicated that they will accept applications under the dates of filing, so we're getting another month's time for all those who have been in that situation where whether they want to file or not file, who've lost the chance in October, still have a chance in November. So at least now they can, turn their situation, and if they decide to, with the help of their employer, if they are amending it, then they can file their applications with the downgraded EB3. For those of you who are clearly qualifying, whether it's the EB3 or EB2, highly recommend doing it because we never know when we are going to see this bulletin in this format. The last time at least me as an attorney, the last time I had seen it was back in 2012. So after that, it's almost 8 years later, we are seeing this lucky chance that I call it, through which you're at least able to file for the adjustment of status and get into the line at least one step away from getting a green card. I know there's still a long waiting because of the final action dates not being current, but at least your foundation would be that. And we'll also be discussing about the interim final, the H1B, as most of you know that the Trump administration has introduced the interim final rules in which they've given a 60-day window through which they are going to propose the changes and bring back definitions of what is a specialty occupation. They're going to redefine it for the interim final rules. They're also going to redefine the employer-employee relationship. And they've also indicated that with final rule that any employee who's going to be placed at a third party location or working for an end client in the past were given 2 years or 3 years extension, which is now going to possibly come to a stop, and they will give only 1 year extensions. There have been a number of lawsuits that have been filed, at least to my knowledge. There are 4 lawsuits, including IT has filed a lawsuit on this matter, including the wage increase that has already taken into effect on October the 8th. So there are some lawsuits pending, but what will be the outcome is to be seen. IT Serve was lucky the last round when they filed it on the employer-employee relationship. Those issues were gone after that lawsuit was won by the IT Serve. But we don't know if this is a backlash to that, or we may see even further backlashes to similar lawsuits. We yet to wait and see what will transpire after November 3rd, which is the election date. So there's a lot to do with the election, also what's going to come out of all this. But I'm just bringing out all the information for most of you. If you know it or you know it, then at least aware of that. The next thing that was introduced just a couple of days ago by the Trump administration was that they would be revamping and changing the H1B cap lottery process. As you all know, in 2020, they introduced a new system called as the registration. And through registration, you could actually register for the lottery online, which initially a lot of us had fears, but I think it turned out to be pretty good, wherein you were not mailing huge packages by FedEx and spending all that money, and the packages were coming back to the employers. So it was a good deal that you could do this online. And once your registration was picked up, you came into the lottery, then you were given a time frame to file the H1B application, which was a win-win for both the employers and employee. But now the Trump administration wants to do away with that, and they're introducing a policy where they are going to go by the wage levels, and based on the wage OES wage levels, they're going to do the random lottery selection, which to me is unconscionable. I don't think it would be a fair system, but that is what's going to go through. Or will we see some lawsuits? Once the final rule comes out, we can file a lawsuit when it's still in a pending status. So we have yet to see what's going to come out of that. I just wanted to touch base on all these things. And if you all have anything that you want me to particularly talk about, we can focus on those matters.
So Uma, this is Vijay again. So this webinar is getting broadcast on social media channels, Facebook, YouTube, and other channels. As we are discussing these pretty hot topics here, we have some questions that were asked ahead of this webinar. We have a list of questions. We also have people asking us in real time. People are concerned with lots of questions given the topics that you mentioned. They're so hot right now. So they have plenty of questions. So we will fill that in as you explain these concepts. We will also try to bring in some questions from the audience as well as some questions that were already asked.
Sure.
I want to quickly take this opportunity and to introduce our NATS president who joined us a few minutes ago. His name is Vijay Shekhar Anne. He took over as NATS president this year, and he's pretty young and energetic. He's filling us with lots of passion, and I met him last year at the NATS convention, which was a pretty big event in Dallas, and you could see all the energy that he's put into the NATS convention, and it's very inspiring, his leadership. So without much ado, Vijay Garu, if you want to, another Vijay. Hi.
Thank you, thank you, thank you very much, Vijay. Thank you, Hemant, and actually the whole NATS Houston chapter for bringing this so quickly. As soon as things move on, we are all on track, trying to help our members and our community to understand what's going on the changes. Thank you, Umaji, for coming in and helping us and getting this webinar going with such a beautiful information that everybody is waiting to know about. I don't want to take too much time here. Thank you very much. Good job, Houston chapter, and I thank everyone. Thank you, Umaji. And obviously, all my members and all the viewers, our NATS helpline is there. It's 1-888-4 Telugu, or you can email at helpline@natsworld.org. Any emergencies or any help you needed, just go ahead and send us an email or give us a call. We have a 24/7 helpline, and we are always available. Thank you very much.
Thank you, Mr. President. Right. So let's.
And quickly, I have to get on to a different meeting too, so I will drop off. But anyway, but I'm listening still. I'm on on my YouTube. So,
thank
okay.
you, thank you,
everyone. Thank you.
Yeah.
All right, thank you.
All right, Umagar, let's. Do you want to present your presentation, and then we can go into questions, or do you want to take questions first and then slowly go into?
Let's take questions first, because I know a lot of people are anxiously waiting to get their questions answered. So I would very much encourage that. And also, I wanted to, on a different note, thank the entire NATS team for bringing me onto this platform, and want to assure you all that whatever process you have gone through, I have gone through a number of years ago. So I pretty much understand the pain that each of you are going through and what it means to get a green card or become a citizen much later and establish your lives with your family. So I fully understand. So since I've gone through the process myself, I'm empathetic to each one of your situation. Of course, my time, things were much faster. We didn't have to wait in line for 10 years or 15 years. We filed a perm and got a green card in about 1.5 to 2 years. So the waiting line was much less. Definitely, that is a different scenario, and this is different. But I definitely understand each one of you, all your pain and your agony, your frustration that you are going through. And secondly, I also want to say I'm Telugu. So if somebody wants to ask me a question in Telugu, నేను తెలుగులో కూడా మాట్లాడొచ్చండి.
చాలా మంచిదండి, థ్యాంక్ యూ వెరీ మచ్.
వెల్కమ్.
So NATS serves Telugu audience, and also in terms of service, we also serve beyond Telugu as well. So we got our first question from somebody called Lawrence, and his question is, which I mean, as you rightly said, November Visa Bulletin is basically a copy of October Visa Bulletin. They say basically change is constant, but actually constant has become the change now. so taking that into account, his question is more towards, okay, it's a very hot question, everybody that's asking, what's your prediction for December Visa Bulletin, being so knowledgeable in this area, right? And he's referring towards EB1 in terms of data filing. But in general, probably you can talk about what's your predictions towards December visa bulletin.
From what we have heard from Ayla and also knowledgeable attorneys is that most people are expecting the visa bulletin to jump in December as well as in January 2021. They're expecting possibly the EB1 category to even become current for India. This is the prediction that we've heard. These are all, of course, from discussions, nothing that we have concrete. So I cannot, blame someone for giving me this information. This is coming out of discussions that they've seen the visa bulletins in so many years, and based on that, their prediction is that possibly we may see a big jump in EB1 as well as quite a big jump in EB3. Now, I am definitely looking for the magic lamp, Aladdin's magic lamp, where I can rub, and trust me, my name is Mantravadi, so I'm trying to see if I can do some.
You can do the abracadabra there.
Absolutely.
All right, that's pretty good. We have more questions pouring in through social media channels and
sure.
other things. We're waiting. So here you go. One second question here. So people want to thank you first for your time on doing this on a Friday evening, late night. So that's pretty. Thanks for doing this for the community. Along with NATS, I think the audience are also very grateful to you. So the specific question here is, which H1B rule will be effective after the 60-day comment period? I'm hoping he said which H1B rules will be effective after this 60-day comment period. So there are multiple, right?
There are multiple of them, correct. The first one was the interim final rule comments, which are open right now, which is due to take effect on December the 7th. Having said that, there are numerous lawsuits that are coming out. So if the lawsuits are successful, we may not see those, or we may see a settlement agreement between the government and the people who filed the lawsuits, or we may see that the government won it and it may go into effect. So we have yet to wait and see what's going to come out. But definitely right from day one, the Trump administration, the entire premise of President Trump's election has been about immigration. So he's been very strong that he wants to combat not just illegal immigration, but he wants to tighten legal immigration. And because a number of people feel that the H1Bs are taking away their jobs, so the focus has been on H1Bs, unfortunately. They don't look at the L1s the similar way. They don't look at TNs in a similar way. But for some reason, the focus has been on the H1s. For two reasons, they feel that the H1s are taking away American jobs. Two, they feel that H1B workers are underpaid, so because of which the jobs are easily gone to an H1B worker, which is why they've come up with the wage increase, and I've given that in my PPT. If you look at it, the percentages, what it's gone up by. Level 1, level 2, level 3, and level 4. Each one of them, the percentages have gone up. Now, in reality, can mom and pop kind of employers who run small IT firms, with 10 employees or 15 employees or 5 employees, would they be really in a position to pay, let's say, a programmer analyst from Houston who's right now getting 75 or 80, and if they have to pay them 125 or 130, when the end client is not willing to pay that kind of hourly rates, it may be impossible for those employers to continue their business if this happens, and which is why right now there are at least 4 litigations that are pending as the wage increase. So we may definitely see that the wage increase may come back to its original for a time being, or once the election is done, and if President Donald Trump is back, we may see more action, or if this presidency is gone, we may see some of these executive actions gone out. So
Got it.
let's hope and pray for the best.
Yeah. So most of our questions comes with the person's name who asked it. Some of them do not. So in respecting everybody, so probably we're not really reading out names here. So
no problem.
I guess probably whoever asked that question on what rules will really become active got their answer there. Thank you for that. And so this is a peculiar case here. And the next question is more towards in this scenario, there's a wife and husband both has 140 filed individually. The question is more towards, could you explain more about transfer of underlying basis? What the follow up to that, what they're asking is, does it allow for spouse to become primary applicant if that 140 date is more favorable, if her 140 date is more favorable? That's
okay. I'm trying to understand the question, and I'll repeat it. My assumption out of this question is, let's say the husband has EB2 and the wife has an EB3. Both of them have the perm and the I-140 approved in different categories, EB2 and EB3 category. Now let's assume that that they filed the 485 under the October Bulletin using the wife's EB3 category. I'm just giving it as an example. And the husband's EB2 category has remained intact. Nothing has been done about it. Now, if they want, let's say the December bulletin or the Jan bulletin is more favorable for EB2, then definitely the husband can become the primary applicant for the adjustment of status. He was now the derivative applicant under the wife. Now he'll become the primary applicant, and his wife can be the derivative applicant for the adjustment of status. And it's interesting, Vijay, you can actually have 2 green card applications running parallelly. Not that they are going to give 2 green cards. At the end of the day, whichever makes, reaches the finish line first, they get the green card on that. If in the running race EB2 gets there first, then they'll get the green card based on the husband's EB2. Or if the wife's EB3 is reaching faster, then they get a green card through the wife's EB3 category.
Yeah.
So definitely they can file both applications. There's no limitation to that. Added to that, I'll just give you an extra added example. Let's say the wife has a sister, and the sister is a US citizen, and she's filed an application under the family category for brothers and sisters. Now they can have a third application that is running concurrently, and the USCIS has no objection to that.
Okay, got it. So I guess your assumptions are definitely matches with mine based on the question. So I'm hoping we definitely answered their concern. There is one more follow-up to this whole discussion, and then which kind of falls into a general question as well, where if can one person, typically most, I guess the people who are applying right now are applying with a wife and husband combination, right? And some of them have a case where husband might have a H1B visa, wife may be on a H4 EAD or on a H4 visa. Question really is, can one of them end up using EAD but not both of them? Those permutations, combinations that are possible, right? I mean, husband uses, wife doesn't use, husband doesn't use, wife uses, and what happens to their status and all these things. It's kind of a little confusing at that point on what are the different scenarios are, right?
Sure. It's a very good question, a valid question. This has come up even a number of times during the October visa bulletin, where a number of people had this question. One of the things as attorneys, and even with the recommendation of AILA, we have been telling our clients is now, for example, the earlier situation, you have the husband and wife with different categories, and let's assume the wife is using the wife's EB3. They both filed their adjustment of status. Now, like you said, the scenario comes up where the husband loses his H1B. He's laid off. And the temptation is, hey, I've got an EAD. Why not I use it?
Right.
Because I don't have an H1. I can't find an employer in 60 days who's going to do my H1. Can I use the EAD? He has it and he can use it.
Definitely.
But what happens is once you use the EAD, you're availing the benefits. Once you avail the benefits, there are two issues. One, you get married to that EB3 category. Okay. Now, there is still the EB2 of the husband. Can he not file that? He can still file it. Nothing is taking it because he's not filed his EB2. He has a right to. If the priority date becomes current, he surely can. But if the immigration officer feels that he's used the benefits of the EB3, meaning the EAD or the advanced parole, there may be some issues that would come up. Now, what could be the issues? How would the officer handle it? We'll have to wait and see. We can't predict exactly what the officer can do. Can they stop him from continuing with the EB2? I doubt it. They will still have to allow him to. But the only question comes that you have used the EB2, EB3, EAD, the benefits of the EB3 EAD. There's a second issue to this, Vijay and everyone. Let me also clarify this. As all of you know that, every H1B gets only 6 years. And you get the additional 3-year extension because of the AC-21 rule that was passed during Clinton's time. And if you have an I-140, you can keep getting the 3 years indefinite extensions. So the purpose of that was to ensure that people maintain their H1B status until they get the green card. So once a person starts using the benefits under the EB3 or EB2, whatever category, and if you don't file your H1, and at some point, if your adjustment of status is denied, then you cannot come back to your H1B status. So which is why attorneys like me, I've been advising this all along to my clients, no matter what, please try to maintain your H1B status. So you will not, for God forbid, for whatever reasons, if the employer has gone bankrupt, they've closed business, the employer doesn't want to support you, when your adjustment of status interview is there, let's say you have to ask the employer's tax returns, they don't want to give it to you, or they've closed shop, and you've lost your H1 because you're not maintaining it. So you would have issues at that point in time.
Yeah, that's a very valid piece of advice. Thank you for that, Mantra. Uma. I guess everybody has a story here in terms of immigration, right? Different stories, different questions coming here.
Absolutely.
Yeah. So, so we have a H1B related question following up here. So, what would be the preferable wage a candidate should have to secure the H1B visa based on the new proposal out?
They have to ensure that the employer meets the prevailing wage of the offered employment, OES. Now, attorneys, we are all not using the FLC data center prevailing wages because those wages are higher. So we are going and using other wage surveys. There are many surveys. and USCIS allows us to use those surveys. There's nothing wrong about it, nothing illegal about it. So we actually provide that survey to the Department of Labor, who in turn then approves the LCA. So we can use outside surveys in order to get a more competitive wage. If you go with the FLC data center, as I told you, and I'm going to pull up that the level 1 wage has increased from the 17th percentile to the 45th percentile.
Wow.
So you can imagine it's double. Okay, and level 2 has gone from 34 to 62. And if you look at most students who are coming out on OPTs, or if they're on STEM, they may not have the experience, so they definitely fall into the level 1. They may not fall into the level 2 as per the employer because they don't have the required experience. So it would become very difficult for an employer to pay this huge increase in wages. So how do you come around that? As an employer, is to look for outside wage surveys and provide that to the DOL so that the DOL can then approve those wages, as opposed to the FLC data center wages, which is much higher. Now, from an employee perspective, employee is going to be happy to get 120 or 130. So they would want to go with the increased percentile. So I'm talking from an employer's perspective, but from an employee, if he or she is an employee, I don't think you should be questioning the wage. Just if your employer goes with the FLC, you're going to get a big wage. You don't have to ask for a wage hike.
So that's pretty good advice, Uma. I guess I went through several years over here, right? I mean, for people, and I still don't have my green card yet. That's my personal experience. For people who are in despair or getting frustrated with the amount of process it takes, I mean, I've been waiting for the last 10 years myself, and I see my kids growing up in front of my eyes, waiting for the card to come, right? So I tend to agree that, I mean, but my point is, do not get frustrated. There's always a way. There's always a way in the immigration. Consult your attorney and talk to them, and even these prevailing wage increases, there is always a way to address that, so that you still can keep your immigration status. So
as long as the employer is complying with the prevailing wage, which is the OES wages as per the SOC code, there should not be a problem in getting the LCAs approved. In fact, just this week, we had filed about 8 or 10 LCAs for H1B amendments, extensions. We didn't have a problem getting it approved. So it's pretty much taking the 5 to 7 business days, and they are approving it.
So if you have any further questions, NATS, our president mentioned about the NATS helpline. You could call us with any questions. So we will post that number in the comments in the social media channels. So the next question here, Uma, is a little tricky here. The audience, one of the questions from the audience is that, okay, what happens? I filed my AOS application, which is I-485, and I'm trying to preserve my H1B status, and my company applied for extension for XYZ reason. It got denied. What is my current situation right now, and how do I handle that?
Well, your employer can definitely file a motion to reopen if they think the denial was an abuse of discretionary authority. If they have sufficient proof, they can file a motion to reopen. And if not, you can also look into options. If your spouse is on an H1, you can jump to an H4 immediately. That is one option. The third option that I tell people, if you don't have any one of those options, your employer is not supporting you, you can file a motion to reopen without the employer's support, of course, is immediately jump into a B2 visa while your B2 is pending, which may take 6 to 8 months approximately. If you find an employer, then you can file an H1 and do a change of status from a B2 to an H1. And Vijay, my firm has been extremely successful on these. And let me tell you, this is not only during the Trump era. I've done this almost 10 years ago, 12 years ago. Every time we've had a depression, jobs have been laid off, people lost jobs. This has happened numerous times, as you know that. The economy is up and down, up and down. So I've had employees who got laid off and we jumped them into a B2, and then subsequently they found an employer and they got their H1 back. So these are options. And I'm not saying everything is so easily done. You don't have a price tag to it. You don't have a frustration attached to it. You don't have the pain and suffering attached to it. There is. But end of the day, at least you have a solution. You're not devoid of a solution.
So one important piece, I guess we should have done it much upfront, is Uma, you might have put your own disclaimer here. As many callers are listening to this live webinar here, NATS wants to put out a disclaimer, legal disclaimer, which basically means in layman terms that anything that you hear, you receive as advice here is do not treat that as immigration advice. Talk to your attorneys, and probably Uma can paint it in the real legal language here. I'm trying to portray in the layman terms so that everybody can understand. This is more an information giving seminar, trying to help the community to clear some confusion out, bringing in experts and discussing the nuances of what could happen. Do not treat this as a pure immigration advice. Do not go by this and say you're counting on this. So that's what we want to put out as NATS. And
Absolutely. Vijay, whenever, we, each one of us, we do these webinars, community services, this is only meant to give a path to people so that at least you know if you're on the right path or the wrong path. It just gives you generic advice. It is not giving you individual advice. In order to create a attorney-client relationship, one has to individually reach out to an attorney, communicate in confidential what their individual case is. Here we're only talking generics, and absolutely this is not legal advice. We're only giving basic general information so that the community who feels they're astray, we're trying to bring them onto a certain track and say, okay, this is probably the path you need to take and go. You still have to consult an attorney and you still have to go on with your individual case. One more thing I want to definitely say, Vijay, you bring out a right point, is that many of us in our community, for anything, we try to copy paste. If somebody is going this route, I'm going to copy paste him. Maybe I'll get my green card faster because Vijay did it. Now that's not going to work. Vijay's case is different. Hemant's case is different. Prasad's case is different. Everybody is different. So if you copy paste, what's going to happen is the results are going to be disastrous. So you don't want to do that.
That's pretty solid advice there. Thank you. Let's move on to the next question here. So in terms of timeline, we'll take more questions and then probably get into the PowerPoint and other things. So this is more a H1B related question. Seems like H1B seems to be the hot topic here. So the question more towards, okay, how, it's more a general question. Okay, what are the consequences of downgrading from level 4 to level 3 to level 2 if my employer agrees to do that? And is it pretty safe, or what are the consequences that I'm getting into? And should I go and, number one case is, if my employer is okay to do that, what will happen? Second is, should I go and ask my employer to downgrade it explicitly so that I can preserve my employment?
Well, it's a very good question, valid question under these circumstances. Let's say you're working at a level 3 right now, and your employer thinks, you know what, we need to downgrade you to a level 1 because of the salary, we can't afford it. But at the same time, we want to keep your H1 active. We want you to be our employee. It's the first thing you have to see is what is the job duties. If your job duties are such that it gives you a lot of independent judgment that you can make, then you're not a level 1. You're definitely a level 2 or 3. When you're taking independent decisions, for example, you know, you don't have to call your employer to ask, do I need to do this? Do I need to do that? I need your direction in this. Should I be doing it in this format? It's a SAP program, and you know, I want to do it this way, but what would you say? So then you don't have the independent judgment and you're at a level 1. But if you are taking independent judgment and you're making decision at that project, you don't consult your employer to do that, then you're definitely not a level 1. So your job duties will determine whether you're a level 1 or a level 3. The job title does not. You could be a software engineer being in level 1 also, or a level 3. Sometimes you can add the word senior, but then again, just the job title alone will not determine whether you're a senior or a junior or a startup. It is your job duties that encompasses what you're going to be doing, whether it's a level 1, 2, or 3. So if your employer decides to bring you down from a level 3 to a level 1, please make sure that the job duties comprise the level 1 duty determination. Otherwise, you're going to get an RFE and you'll get into problems.
Okay. Switching again to green card related question, Uma here. So the question is more towards somebody's priority date is April 2014 on EB2 India, and the question is, is it really worth it for me to go for EB2 to EB3 downgrade at the moment, given all the movements? And if the downgrade for XYZ reasons gets rejected, what happens to my current EB2? Please explain in detail. Thanks. That's the question.
Sure. I cannot tell you whether you should downgrade or you should not as an attorney. Even if you were my client, I would have to say the same thing to you, because that's going to be an individual decision whether you want to jump into the EB3 line or remain in the EB2 line. Now, I can definitely tell you what can happen if your EB3 application adjustment of status, and there are two ways of looking at it. The word rejection, Vijay, rejection means your application was not even taken in. Your checks were not even cashed. They rejected it back due to technicalities. For example, the forms were not completely signed. The fee was $1,225, but you put only $1,025. You made a mistake, or you did not submit the 944s that was required. So then they reject the whole package back along with your checks. So they've never even accepted, they've never processed it. Now let's assume that was the wrong terminology somebody used, but he's using the word denial, you know. So if the case is denied, but before they deny, whether it's an adjustment of status, whether it's an H1, L1, H4, any of them, the policy, the standard operating procedure policies of USCIS is that they have to issue an RFE. They have to do that. Or if they feel your case is something fraudulent or they've done some investigations, then they issue what's known as a NOID, which is a notice of intent to deny. So without those, they usually don't come out blanketly and deny. But let's go to the extreme and say they've denied it. They've denied your application. Your EB2 is still intact. Nothing has happened. What have you lost? You've lost your fee because that was taken, 1225 was taken for you or for your spouse, and you've lost the money. But you haven't lost your place in the EB2 line. You're still back intact in that position.
Looks like that's not a bad bet to take then.
Well, sometimes, it's like people say, okay, today Microsoft stock is great.
Yeah.
We buy it. But tomorrow Microsoft may go down. There's no
Short-term
guarantees in
crash.
life.
Yeah, exactly. Right.
But do you want to take an educated risk? I think we all have to.
Definitely. Absolutely.
I'm just being funny, but people say, do you want to get married or you don't?
That's a good example there.
I'm just kidding, guys. Clement is going to say, Oma, that's it.
Right. So we're pouring. I mean, questions are pouring on social media. We're
Let's
trying
move
to
on.
bring them in as they're coming.
Please.
Definitely for the viewers, we may not be able to accommodate all the questions, but we're trying to see, making sure we make good use of the time here. Okay. So this question is more towards a general. There's a general question they're asking, and followed by some specifics there. How flexible it is to transfer these pending applications between those processing centers. Their application has been haven't moved. Um, um, so L1A to F1. This is the transition they are trying to do at California Processing Center. They haven't. Nothing has moved since April 10, 2020. So they want to do change of status or from L1A to F1.
Okay.
And they applied to California. Nothing has moved since April 10, 2020. So they're asking about how flexible it is to move cases between processing centers.
We don't have the authority to move it from one service center to the other service center. It is only up to the USCIS. If they feel that one service center is overburdened with cases, then they send it to, let's say, to Lincoln, or right now they even have Potomac Service Center, or to the Vermont Service Center. So that is an internal policy that they take, but we as attorneys or as individuals, you do not have the authority to determine which service center it can go to. Now, what can you do is definitely you can raise a service request, send them an email, or call the 1-800 number to find out what's going on. But please realize that since April, there have been considerable delays, and right now we are seeing a number of cases where the biometrics have been issued. In this month, particularly October, has seen a huge surge of biometrics being issued, whether it's an H4 or an L2 or an F1 or an whichever category they are. We are seeing a huge surge of biometrics that are coming through. So there's a good possibility that you may see the biometrics. And once the biometrics comes through, we are seeing even the approvals. Just to give you an example, Vijay, I had a client who filed for a B2 extension because they couldn't go back due to COVID. And it was pending since April, and they just got the biometrics in September. And in October, they got the approval.
Yeah.
So we are seeing that. So I know it's frustrating for this individual, but be patient. But if I were you, I would definitely call the toll-free number and see if you can raise the question to a tier 2, ask for an officer at the tier 2 level, and let them know that you're anxious to start school and you may miss the semester, which is coming up in Jan. So maybe you may see something better with that.
So I'll just add to that question. The question was more towards F1. You did mention that we do not have the flexibility to make them transfer the cases. Is that a universal thing across any type of cases, like 485s, H1Bs? They go to different processing centers, right? So is that pretty much true with any case?
Absolutely. Absolutely, because they don't allow you to call forum shop a jurisdiction. Let's
Got
say,
it.
for example, you see a pattern that Texas Service Center is giving approvals much easier than California. So then people will want to file with the Texas Service Center. So they don't allow you to what's known as forum shop. You can do a jurisdictional shopping.
Yeah, and
So
it can
you have to find.
overburden the system as well, right? I mean,
Correct,
yeah.
correct. It's the same thing. For example, Vijay, when say let's say somebody files for a divorce in a court in Texas. I'm just giving as an example. If let's say Judge A is a very nice judge, very lenient judge, I cannot file it in his court.
Mhm.
It's a bingo system. The court system decides whether I'll go to A, B, or C.
Got it.
That's the way it is, and so it's the same thing here.
Got it. Cool. So next question is more towards I guess people have lots of worries, lots of thoughts on okay, what's going to happen in the next few days, given those rules that are proposed rules that are floating around out there, and to kind of balance them, their lawsuits. There were lawsuits that have been filed. You did mention something about a lawsuit that is active out there. The question is really towards okay, when will we know if a particular lawsuit was successful or not? Take the lawsuit against a prevailing wage, right? Is there a way we can keep tabs on it and then get to know the status, so that we probably we could get relieved if that goes through well, right?
Absolutely. It's a good question. Maybe one way is once I get information, like one of the prevailing wage lawsuit I know is coming up for a hearing on November the 15th. It is set for an injunction hearing, and that's the date for the hearing. But that doesn't mean the judge is going to make a decision the same day. They may hear testimony back and forth from the government as well as the plaintiffs. So it may take a few more days before it's all published. But the question is, how does this individual come to know about it? Vijay, I'll be glad to provide this information to NATS, and possibly NATS can post it on their website.
Our pleasure. Thank you.
Mhm.
So, going back and another EB2, EB3 related question.
Sure.
So, his priority date is EB2 2011 May. I'm assuming India.
To
Based,
2011 May.
yeah.
Okay.
And
May 30th.
May 30th. And
Okay.
oh, the date has a significance there. Okay, okay.
Correct. Absolutely.
So I excluded the date. So thanks, Hemant, for filling that in.
Yeah.
So my employer is not willing to downgrade. What are the options do I have right now?
You missed, I mean, it's just 15 days away under EB2. Your date is May 30th, and the dates of filing for India EB2 is May 15th, 2011. Unfortunately, you're just missing the boat just by a few days. What are your options if your employer is not willing to do a couple of things? Just wait for the December or Jan bulletin to see if the priority dates are current by then, meaning the dates of filing will allow you to file, then you may be in a good position to file it at that time. And hopefully your employer will give you the I-485J so that you can complete your adjustment of status filing. Now, if your employer doesn't give, I'm going to the next step. Even if the priority date becomes current, not priority date, the dates of filing becomes current for your priority date, which is May 30th. Let's assume it's December or Jan. I would definitely file the adjustment of status without the I-485 and under AC 21 after 180 days of pending of the adjustment of status, you can port it to a new employer. If you have a new employer who's willing to port this entire application, then you can port it to them and they can provide the 485J and you can get a green card through that employer. And let me also say, you don't have to be employed with that employer. You can still be working on an H1 with employer B who's not supporting you, but employer C is willing to port it, you can still file it without having to work for that employer.
Thank you very much, Uma, on that. So next question is more towards H1B and the grace period associated with it. I guess there are a lot of gray areas there. People I see a lot of questions around that. So the question is really towards, okay, some XYZ's employer, XYZ had a layoff at his company, and his employer immediately filed for revoking of his H1. In this scenario, XYZ thinks that his I-94 is not valid anymore. So in this particular scenario, is the 60-day grace period still applicable or not?
Absolutely. Absolutely, it's applicable to you from the last date of your paycheck, not a severance package, but your paycheck. Let's say the last date was October 29th. So you have 60 days from that period to find a new employer. And even if your H1 is revoked, it doesn't matter. You get the 60 days and you can file for an H1B change to another employer. Again, Vijay, let's assume they can't find an employer in 60 days. During COVID, and especially it's the last quarter of the year, a lot of employers are not in a position to hire. I would say jump into a B2 and then jump it back, do a change of status back to your H1. So what happens is you are not falling out of status, you're maintaining your status, and you can jump back anytime post 60 days period. So at least you don't have heartburn, that you're worried 60 days are gone, I don't have an employer, what do I do? So if you can find and you think realistically it's not going to happen, spend that money, get your B2, you'll be fine.
Thank you, Uma, on that.
And on an extension of an answer to that, let's say they're not even finding an employer right away, even after the B2 is filed. I can't find an employer, nobody wants to hire me. What do I do now? I can't be sitting idle. I need to do a job. There are many people who go back to school. They go back to school, get an F1 status, and sometimes after the first semester, you can get a CPT, and then you're employed again. So, but you've got to go through this little process. And I fully understand it can be very frustrating. But I keep saying, when one door closes, the window is opening.
Don't
but
give
none
up.
of us are watching that window. We're only looking at the closed door.
Yes. Don't just give up hope.
Absolutely.
Yeah.
So this is another interesting question, right? So we're in the midst of pandemic, and pandemic has created some positive things for a lot of immigrant people with this priority date movements, and also create a lot of confusion with the layoffs and people getting stuck in India. So this brings up an interesting scenario where someone's wife is stuck in India right now, and this person is eligible to file in EB3 category in October Bulletin. So how to file for her? So that's the question.
Well, unless she comes back, she cannot file for the adjustment of status, unfortunately. Adjustment of status is an application only for a person who's here, who's changing or adjusting their status. So it cannot be done during a person while they're in a consular processing. So what they have to do is file for their adjustment as the principal applicant. And whenever the derivative applicant can come into the country, and if the visa bulletin dates of filing are still allowing them to file, then the derivative can then join in her application or his application at that point in time. And because this is COVID period, they can explain that they could not file it concurrently because she was stuck due to the COVID pandemic and she could not come in. And also because the consulates are not open, they're not giving interviews for anyone to get a H4 to come into the country.
Okay. So this is another prediction question here. Get your magic lamp ready and ready to say abracadabra.
Absolutely. Either that or I have to go to Hyderabad and get a parrot,
Yeah. So
from the railway station, the parrot that's going to predict.
yes. So question really is: do you think EB1 will become current in the coming month? Especially there was no change in the November bulletin, and many of the immigration attorneys were talking about some rapid movements. We haven't seen that. What do you think about EB1 specifically becoming current in the coming month?
Again, upon the discussion with AILA, a lot of the AILA attorneys, we've been told that we will see a rapid movement of EB1 and possibly in December, Jan. There will be some forward movement and it will be rampant with EB1. It may even become current as what we've been told, but again, a lot of things are going to be interdependent on this election. What happens will all depend on that.
Wonderful. So another GC related question here. No predictions, thankfully. If my current company files GC and after 6 months I left the company and joined different company, will my GC application remains valid? I guess he's referring towards that 180-day period or something like that, 6 months kind of.
No, he's just worried if the 485 will be denied, if he leaves the employer with whom or through whom he has filed his adjustment of status. No, nothing will happen. Your employer does not have control on your 485. Your employer has control on the I-140. So they cannot withdraw anything. That application is yours. At the most, the employer, out of spite, out of anger, out of whatever, they can come and withdraw their 485J, which is fine. Now, if you go past the 180 days, you can port it to another employer. So your 485 will remain intact. Your 485, your I-765, your 131, nothing is going to be taken. That is your application, not your employer's.
Thanks, Uma, on that. For all the viewers, again, just want to make a point that feel free to contact Mantra Law Firm based in Houston, founded in 1994 again by Uma Mantravadi, and she has been pretty prominent in the community here. She has gained a good amount of reputation in terms of the personalized services that she was offering in terms of immigration. Again, immigration can be complex and daunting at times, so seeking good legal advice is very important. Thanks, Uma Garu, for taking your time again.
Most welcome, Andy.
So we'll continue with the questions. I just want to
Absolutely.
bring in that message once again, as our viewers are, some people are kind of coming in, going out, so kind of to establish a context once again.
Sure.
So another question here on 485s here. This is a more general question, and his question is more towards, okay, what are the common reasons for denial of I-485, especially if there are no applicant is clear of any criminal offenses and any such aspects?
In my experience, Vijay, I've not seen a denial. But let me take the extreme step and see if there is a denial. Usually, if they do an investigation and find out that the employer never existed, that is an extreme case I'm talking, or the employer has closed business, they no longer exist because of that. So that would be a situation which is clearly a very extreme situation for them to deny it. But like I've previously said, the standard operating procedures for the USCIS is if they have any conflicting issues that they find, they are required to raise an RFE. they cannot flatly come and deny it. They have to give this individual either a notice of intent to deny and give 33 days time to rebut to the notice of intent to deny, or they have to give an RFE. And I do a lot of family-based cases also. You know, sometimes if they are suspicious of the marriage, it could be a sham marriage or fraudulent marriage, we still see that they have to raise an RFE or a NOID. Without that, they never deny it.
Got it. Got it. Okay. So another specific question here on the 485 application. I think one of the audience was he was saying he mistakenly did not disclose his previous visa denial on the 485 application. Can he take any corrective actions at the moment right now, or what could be the consequences?
I wouldn't rock the boat right now. I wouldn't. Okay, it was a mistake. If you forgot to mention something that should have been mentioned, again, if they find out information through their own investigations, then they will issue an RFE. At which point in time you can give the explanations why you felt that you answered that question in that format. Maybe you misunderstood the question or you misread the question, and now you are providing the information. For example, your visa was denied, but it was denied for wrong reasons, and you didn't think much about it, and so that's why you didn't disclose it. So I would definitely wait and see what happens. They're not going to do anything right now. Especially, Vijay, because all these 485s are not being filed under the final action dates. They're only being filed under the dates of filing.
Right.
So basically what's happening is they're accepting, they'll be pending, they'll issue the receipts, biometrics, probably the combo card of the EAD and the advance parole. It's going to sit there. They're not adjudicating it further than this.
That's
So
pretty good.
all these issues will come up much later. But if they feel, hey, there is not even an employer that exists, then this 485 doesn't exist.
Got it. Got it.
They're looking at the foundation, not the little matters.
Got it.
And
Got it.
sometimes I've had people, let's say in a citizenship application, they've forgotten to mention that they had a criminal conviction. Okay. But that doesn't still deny the citizenship application. They'll come and ask for additional documentation, meaning they come and say, get us certified copies of your criminal conviction. Let us know what happened. Were you on a probation? Were you in jail? Did you pay a fine? What happened? Give us all the history. So the case is not denied.
Wonderful. So more questions towards interfiling requests. So they're asking us to explain about, okay, can you explain about my interfiling request, and can we file another set of 485s in case interfiling request between principal and derivative is not working?
I would always do a separate filing to avoid the confusions. Now, let's say we talked about the scenario earlier where husband and wife had EB2, EB3, but under the October Bulletin, they chose to file using the EB3 dates of the wife. And now the EB2 dates of filing has come up. I'm not talking final action, but the dates of filing. Instead of making a request of interfiling, meaning use my 485 from EB3 to EB2, that's a lot of confusion, and it is possible legally, but practicality beats the legality sometimes, and I would definitely recommend those individuals to spend the money and file a separate 485 under the EB2 category. That way you have two applications, and whichever comes to the finish line first, you take that one.
Okay. Thank you on that. So I want to take this opportunity again to introduce our local Houston chapter coordinator. His name is Viru, and Houston chapter was founded by Hemant Kola. He's in 2017, and in lines with the NATS principles nationwide. We are continuing our service in Houston and surrounding areas. So without much ado, Viru, take over and.
Sure. Thank you, Vijay, and thank you, Uma ji, for joining the webinar. I take this opportunity that session is very informational for a lot of viewers. Hope you use it. Bhashe Ramyam and Seve Gamyam is the motto of NATS, which is the sole importance of two important aspects. One is the language. Telugu ప్రేక్షకులకి బాగా దగ్గరగా ఉండే కల్చర్ని పెంపొందించడానికి we connect through the language and also the service. Since Houston chapter is formed in 2017 and we started, NATS was established and participated in a number of service related activities in Houston and surrounding areas. We started off with the Harvey relief efforts, and then every year during holidays we distribute food and through to the poor people, and also we do the million can events. We recently celebrated Balala Sambaralu, which is a successful event and established connectivity with the NATS Houston to the people in Houston and the surrounding areas. This is not possible. We have a young team. We are growing, and this is not possible without our core team members. You see Vijay, Hemant in the call, Srinivas Kakamanu, who's taking care of a lot of back-end work right now, Chandra Thalli, who is our sports coordinator, and Sunil Paleru, and they are the national board member who is from Houston, which is a good opportunity for all of us, and I thank everyone, and also thank National NATS team for providing such a platform to support and do a good work for to this community. Thank you. And back over to you, Vijay.
Thanks, Viru. Thanks for the leadership you were offering to the Houston chapter. Umagar, just for planning purpose, we are 1 hour 17 minutes since we started, and we have lots of questions pouring. Looks like there's no end to this. So, but at the same time, we want to make good use of your time and everybody's time.
Absolutely.
Do you want to put a
And
cap
I
on?
want to I want to assure Hemant Garu and yourself and your entire team, we will try and answer as many questions. I'm not putting a cap to the time for today, but if the need comes, I will be willing to come back, do another webinar in a weekday or a weekend, whatever your team decides. I'll be glad to do a continuation of this. I have no problem.
That's pretty
Thank you.
good. Thank you very much. We appreciate
You're
your
welcome.
dedication and service there. Without much ado, next question will be more towards I-485. So this is a very pressing question. I think I sail in the same boat. This is more towards the travel restrictions with coming towards 485, right? Somebody files I-485 and they want to travel outside of the country. They are on H1B. They're on H1B. So what happens if there is a case of emergency and they need to go out since the date they filed I-485 and before they get their EAD, and maybe once they start using EAD and then before the 180-day period or different scenarios, right? This is more towards the travel. What kind of restrictions are there?
Right. Let me generically say, first of all, whether you file an H1B, whether you file a 485 or an L1, if you leave while the application is still being adjudicated, it is considered that you abandon it. Like for an H1, while your H1 extension is pending, if you leave, they consider that you've abandoned. Now you've got to go and do a consular processing. Similarly, for an adjustment of status, which is why we recommend that people file for an advance parole so that it would not be deemed abandoned once you file. And let's say you have an emergency that you have to visit a family and you need to travel, but you haven't gotten your combo card, which is the EAD combined with the advance parole, but you have to leave. My advice would be to ask your attorney to get an emergency info pass and get you at the local office, like Houston field office can issue an emergency advance parole, and you can take that and travel. Now, let's say you can't even get that due to the pandemic, they're not issuing it. I would at least take all my receipts, my biometrics to show that I've completed everything, but due to the pandemic and the delays, I was not issued my advance parole or my EAD. But I do have an H1B stamping, which allows me to come back. But I've not abandoned my application because I filed for the benefit, but I never received the benefit in a timely manner. So this is what I would do. But the first step would be if you're traveling and you're traveling within a day or two, I would somehow rush, get an info pass, go to the local office, show them your emergency, and they will issue an advance parole locally.
Wonderful. So this is a follow-up question to the previous question that we got on H1B layoffs. So like how you're saying about if an H1B employee was laid off and he applies for B2 visa to maintain the immigration status.
Right.
And then later he finds an employment, the B2 is still pending, and then
Right.
he finds an employment now. So
Right.
that can does this come under the bridge concept? And can we file H1B while B2 application is pending?
Absolutely, you can. You can show them the receipt, and if by then you've already completed the biometrics, I would show them. Because the delay is not on your side, the delay is on the USCIS side. They have delayed the process. Otherwise, you would have received your approval by now. So we've done many of this. We call it a Band-Aid, change of status. You got laid off, you find your B2 change of status, your B2 is pending. While the B2 is pending, now you're switching to an H1 or an F1 or any other category.
Okay, so there is another.
It's very much possible. Using your notice of receipt, you can file for the change of status.
Okay, so I'm reading another question here.
Sure.
So my GC priority date in EB2 category is June 2012, and I want to downgrade to EB3 category and file 480 and 585 concurrently. Now, while my 485 application is in process and EB2 final action dates become more favorable at that point, would I be able to switch I-485 from EB3 to EB2? If yes, what are the underlying risks that I have to go through?
As we talked just a little bit earlier about the interfiling, yes, you can. You can interfile and request them to now process your I-485 under the EB2 category as opposed to the EB3. But there may be some practical issues connected to it, and how efficiently will the USCIS carry out your interfiling is a question mark. So because of that, I personally would advise that you file an independent I-485 under the EB2 category.
Okay, so going back to an H1B question, this is from one of spouses here. So what she's asking is H1B visa of my husband is extended, but my H4 visa and EAD is pending. Can you please tell me how many more months should I wait for it to get extended? My husband's visa extension, again, abracadabra moment, maybe. My husband's visa extension is approved 4 months back.
Vijay, there's been a tremendous delay in the H4 EADs or H4 approvals also. A lot of people have not even gotten their biometrics. So as I mentioned, between September, October, at least my firm has seen a surge of biometrics coming in for the H4s and the H4 EADs. So it is moving, but it is moving very, very slowly. And I'm not sure if most of you are familiar that the premium processing fee went up. I believe it was October 19th. The premium processing went up to 2,500 for most of the H1s. And when they increased the fee for the H1s and 140s, the Trump administration also announced that they would be introducing a premium processing for the EADs, but that has not yet been implemented as yet. They haven't come up, and it's not going to be 2,500. I think somewhere around the fee of 1,500 is what they're going to charge for the H4 or EADs or other EADs. So if that comes into play, they implement that, maybe you can use your premium processing and file it, and they said they would approve it between 30 to 45 days time. So, but that has not yet been implemented.
Okay.
So unfortunately, I don't have good news for this lady, but hopefully, if the premium processing kicks in for the EAD, you can use that and try to get your approval now.
Yeah, first the pandemic and it's the shortage of staff, budget, a lot of things going on at USCIS, and that's trickling down and affecting a lot of people. So this goes back to the marriage question. So let's say somebody gets married, and it's more a referring term, but it's more they use the EB3 EAD, right? So and what they're specifically asking is, are there any? Can you list out this process of going back to EB2 once I get married to the EB3?
Okay.
Assuming that he's eligible for both.
Right.
Yeah.
As I mentioned it right in the beginning when I started my description about this entire process, I said that if you avail the benefits under the EB3, once you downgrade and you avail the benefits of EB3, going back to EB2 will be a difficult issue. I'm not saying it's impossible, but based on history, when we read up the case law or the memos that are distributed by USCIS, we have seen the difficulty because they feel you can't have the cake and eat it too. Mm-hmm. Here you have benefited the benefits of EB3. Now you want to jump back to EB2 because this line is now moving faster and you want to come back to it. But however, you've eaten the cake here. So you're going to have some difficulties coming back.
How about
now,
the vice versa scenario? EB2, somebody using EB2 benefits, can he go to EB3? If
the same situation will arise.
Okay.
And also from the past, what we have noticed is that also at that point in time, they will have questions whether your employer is intending to hire you for an EB2 position or an EB3 position. So you're kind of rocking the boat at that point in time. Now, is it impossible? Can you not handle it? I don't think anything is impossible.
Okay.
You just have to deal with it.
This is
and the way I've done it in all my years of practice, Vijay, is that I don't take no for an answer. I will fight it out, and there are ways, and we're not doing anything outside the four corners of the law. We are still within the law. So we will find the avenues how to handle the situation.
Yeah, it's just that
everything is not written black and white in the law. There are some gray areas. So we look into it, we try to find any case law that can support my client's contention, provide this information in the form of a brief or memo to the USCIS explaining what's happened in the past and how we can apply it to the current case.
Yeah. So,
I mean, it's just like President Trump paying only $750 towards taxes. He found the loophole and he paid only $750, right?
And it's just we just need to know the law better, right? So that's what you're trying to say, definitely.
No,
So
you don't. You need to know the loopholes better.
loophole. Loophole, right? And we're not definitely getting into political things.
No, I'm just kidding. I'm just joking, guys. I'm not
Yeah, yeah, yeah,
averse to Trump paying or
yeah.
not paying. That's
We're
not my business.
definitely. So so another question related to EB2, EB3 here, right?
Uh-huh.
This happens to a lot of people if when people move around between jobs, right? I mean, somebody files the AOS, and then they move, and then the dates move, so they have to. There, some people are in communication with their old employers, and they go and file EB2 to EB3 downgrade with a previous employer, and so they basically filed AOS with the previous employer. So the question really is, do I need to join them after getting GC, or even after getting EAD? Can I port my application to current employer via AC21? What are the rules around that?
Okay. I want to clear a myth that most people are bringing it up in several webinars or WhatsApp groups. So I want to clear that first of all. The I-140 belongs to the employer. The adjustment of status application belongs to the applicant, meaning the employee. Now, for example, like you said, somebody is going down from an EB2 to an EB3. Employer has filed the I-140 and they filed the 485 concurrently with that, right? Is that what you mentioned just now, right? Am I right, Vijay?
Yeah, sorry, I pressed mute by accident.
Okay, no problem.
Yes, that's correct. Yeah.
That's the scenario. And now the question, three questions. One is, do I have to go and work for that employer once I get the green card? Yes, you are required to work for the employer who filed your green card. Whether they did a downgrade or you stayed in the same category, it was based on that employer and that employment you got your green card. So you are obligated to work for that employer once you get the green card. You don't have to work when you get a EAD. You still can wait till you actually get the green card because Vijay, this is an offer of employment, and a perm I-140 is an offer of employment. It's not an actual employment. Unlike the H1B, where you're required to work for that employer immediately upon approval of the H1B. But whereas for a perm I-140 green card, it is an offer of employment. So you work for that employer once you get the green card. Now, let's say for some reason, the extension to that is you were questioning about the AC21. If they, for some reason, they're not in good terms with this employer, they've had some abrasive issues, they're now moving to employer B, they can, under the AC21, once it's crossed the 180 days, you can port it to a new employer completely. But you still, once you get a green card for the employer B, you have to work for that employer B once you get a green card.
Okay. So there is a tricky EB1 question here, tricky to me. so, so I've applied for 140 EB1, but I withdrawn the I-40 application in July, and applied again in October. And this October application got approved now. Now the date of filing for EB1 is September 2020. The question is, can I apply my withdrawn I-40 with the July's date?
First of all, the I-140 belongs to the employer. So it was not you who withdrew. It is your employer who withdrew the I-140 for whatever reasons. And since it's withdrawn, that is gone. It's history. So what you have right now is an approved I-140 under the EB1. I'm not sure if it's EB1A, B, or C. not EB1A, I'm sorry, it should be an EB1B or C. C is for those who are intra-company transferees, and B is for people with extraordinary abilities. So whatever may be the situation, you only have one I-140 that is alive right now, which is the September 2020 I-140. Now, can you file for an adjustment of status? I'm just looking at, I'm assuming this individual is from India. The dates of filing are showing that you can file if it is September 1st, 2020. So if it is beyond September 1st, 2020, you're not entitled to file for the adjustment of status. But the previously withdrawn I-140 is dead. It's gone.
To clarify, it's a self-petition.
So it's a EB1A.
Okay.
B is something an employer files. EB1C is an intra-company, so the employer files.
So
I don't know why he withdrew it or she withdrew it, but once it's withdrawn, it's gone.
Gotcha.
So based on the marketing efforts that we did, right, I can confidently say that most of the questions that we're getting are from country of origin India, people from country of origin India. But to the viewers who have been listening to this from different channels, when you're posting a question, I highly advise that you put the country mention in there, because things can differ based on your origin country, right? So it helps us to answer in the right way for Uma. So next question I have is this is more a H1B question. H1B person asking about his GC. He's working as a contractor on H1B visa. The question really is if the contract between my end client expires or for some reason gets terminated, is that gonna directly impact my GC processing?
Absolutely not. As I mentioned just earlier, H1B is a current employment, and your green card processing is an offer of employment. So your H1B end client's termination of contract between your end client and vendor or end client and employer has nothing to do with it.
Okay, so another scenario here. So I'm on EB2 and priority date April 22nd, 2013. Can I keep my EB2 and file for new EB3 along with 485?
Yes.
Or downgrade? Yeah, go ahead. I'll ask more questions and then we can follow up.
No, go ahead. Go ahead.
Or downgrade from EB2 to EB3 and file for 485. Which option is better? And then pros and cons. And if we downgrade from a lot of questions here, so that's why I'm trying to maybe put a stop at some point.
First of all, yes, you can downgrade and go from an EB2 to an EB3. Your employer has to file a new I-140. If they file an amended I-140, then your EB2 application will be gone. Your EB2 140 will be gone. So most of the attorneys, even under the October 2020 visa bulletin, I have filed numerous cases, and we only filed as a new application. We did not file it as an amended because we realized that a lot of people may be wanting to jump between the EB2 and EB3. So to keep the EB2 alive, we were recommended by AILA and also the standard operating procedures that we should be filing a new I-140. So coming to your answer, what should you be doing? The pros, cons is filing a new downgraded EB3 I-140. That's what you need to do.
Okay, the follow-up on that is if we downgrade from EB2 to EB3 and file 485 together, if the case is pending, EB3 dates are retrogress, and EB2 dates move forward, can we file 485? I guess this goes back to the previous questions. Can we go
Absolutely.
back to file EB2 again?
Yes, you can.
As long as you don't
Yes, you
marry, right?
can, as long as you've not used the benefits,
Yeah.
you're not married to EB3, you can always jump back to EB2.
Yeah.
The policy, I mean, I'm just saying it in a funny way, is that, with EB downgrading to EB3 from an EB2 is you look at the EAD, but you don't use it. So the policy is look, but don't touch.
So,
put it in the locker.
I'm just kidding, guys. I know this can be otherwise a very strenuous, boring topic on a Friday night. I'm trying to make it a little more amusing for every one of us to survive.
definitely. We, and I heard you also sing very nicely, so we could bring some of those songs as well to
Yes,
light up the night.
absolutely. One of
So
these days,
yeah,
once we get over this hump of, the immigration issues that are haunting
right.
people of India, particularly. So I think once this is over, we can all rejoice with some good music.
Okay, wonderful.
It's good.
So my priority date is on November 12th, 2011 in EB2. And I'm downgrading from EB2 to EB3.
Okay.
I've been told that a downgrade must be filed as an amendment rather than a new filing, based on, in brackets, based on new field memo for I-140, new filing memo for 140, new filing original labor must be associated with it.
Right.
And heard there are some rejections happening in USCIS mail room. Is this a temporary issue, or even though application accepted, do we get a NOID later for the new filing of 140 in a downgrade cases?
Good question. As I had mentioned earlier itself, what he's referring to is called as a new field memo. This is a person who works for the USCIS who's issued numerous memos based on the law, to clarify so that the USCIS officers would have a better guidance to how to proceed with the cases. Because attorneys like us, we bring about questions. Every month we have a meeting with the USCIS in each local office, and based on those questions, which are published with AILA, that's what he's talking about, is a new field memo suggested back in 2007 that people file an amended as opposed to a new I-140. But in 2012, when the filing dates were opened up and a lot of people from India were able to file it, instead of using an amended petition, attorneys like me, we all filed a new petition and we didn't have problems with it. Now, a very good question that he brings about the rejection. Vijay, Hemant, everyone, please carefully listen to this.
Mhm.
I have filed numerous H1s, L1s, H4s, B2 extensions, H4 EADs, marriage-based applications. I'm just saying across the field, okay? It takes anywhere between 4 to 6 weeks for a rejection to come back. You can get a rejection in 1 week, in 2 weeks, in 3 weeks. So I don't know who floated or where it got floated, this rumor that we are getting back rejections. I wish USCIS was that quick in jumping and dealing with packages and sending them. They don't do that. They send it by third class mail, and it takes a while for it to come back. And and what we have done just to avoid even the rejections, we've been using an ugly neon color paper that we put on top of the package, on top of the FedEx box or envelope, package, whatever you want to call it, saying that do not return this package. Please take it to the supervisor. And also, let me clarify the people who do the intake of all these applications, they're all contract workers. They're not USCIS workers. So they're given a certain list of things. If you get this, this is the fee. They put it into a fee register, they fee it in. So if they don't know something, sometimes there are rejections, even which are wrong. So which, since we were, kind of appraised about this issue, most of the attorneys who've done this in the past also, we put a note and send it. And I'm not talking only for this EB2 to EB3 downgrade. Sometimes we've even seen H1B packages coming back for no reason. The check amount is correct. The forms are correct. The forms are all signed. There is an LCA. It has all the documents, but they send the package back. So if we see that pattern, we put a note on it saying, do not return it back. Take it to the supervisor. So when they take it to the supervisor then looks into it saying, what is this? Because the intake clerk may not understand all of these details about a downgrade, an amended petition, or a new petition. So they don't understand it. So it is the reason why we've done it, and we've not seen any kickbacks. I've checked with many AILA attorneys if they've actually got kickbacks. Vijay, I haven't heard even one attorney telling me they got a kickback.
Nice.
Because as I said, a kickback in a normal process for any application we've seen takes 4 to 6 weeks.
So lots of rumors around, guys. I mean, it's hard to trust any information, and so that's why one of the primary objectives of NATS and NATS Houston conducting this webinar is to clear up some of those confusions, to bring in those experts in the field to answer them. So seek proper legal immigration advice before getting on to believing in any rumors. So that was a great question. I guess that puts us in a very good context.
Absolutely. And I'm not saying this based on any media news or news reporting. This is actual things that I go through. Yep. Pretty much what we go through. Sometimes there are times you forget to sign a check, then we get a kickback. But that kickback takes anywhere between 3 to 6 weeks.
That's a great point, Uma. So time check here, 1 hour 47 minutes since we're doing this. So what we're gonna do is we're gonna take a couple of last questions, and then probably if you want to present your PowerPoint for a quick 1 or 2 minutes, we can close immediately after that. I mean, that is, we want to help as much as we can to the community. We will take some questions and try to follow up as well. Hemant, we should be able to take more questions offline later, right?
Yeah, we can do that.
Yeah,
and we can always do this kind of session in the future if we need.
Yeah,
and thank you, Magaru.
And in the interest of time, it's almost 10 p.m. in Eastern time. So just want to make sure. So we'll take last couple of questions. Again, going back to this is a frequently asked question. There are a lot of misconceptions on this and travel related. So a lot of people are getting on this EADs and APs in a short while, in the next few months. There'll be a lot of people that you see because of this huge volume of applications, right? The question really is about, okay, can I use advanced parole for travel, but not use EAD for my employment? So I can I still keep my H1 status and use AP to travel. I use AP to travel to India, and I really enjoy coming back more quickly. Actually, no, there's a second level of screening, but I don't have to be on a visa binded approach, right? So there are obvious benefits to that, but the question is, okay, can I use my AP for travel, but EAD, do not use EAD for employment?
Yes, you can do that. Absolutely. But remember, it's a combo card. It is a combo card. It is all in one card, okay? But you can do that. You can use the advance parole, not wanting to go for a stamping, because a lot of people feel very intimidated going to the consulate and getting stuck with 221Gs. We don't know when that's going to open up. So based on that, yes, you can use the advance parole and not use the EAD and continue to be on your H1. That way you're maintaining your status. However, having said that, now you get married to that EB3 because you've used the benefit. Now in the future, will they bring up and say, hey, you used advance parole, we're just going to excuse? In reality, Vijay, we've seen a couple of cases like that where the person used the advance parole, never used the EAD, and they excuse them for that 1 or 2 trips. They didn't make an issue out of it. So it all goes on a case by case with individual officers.
Got it. So another specific question is, in your opinion, is EB2 to EB3 worth downgrade when the EB2 priority date is April 2014? If the downgrade is rejected, I'm sorry, I think that was EB3 probably. If the downgrade is rejected for some reason, what happens to my current EB2? Please explain in detail.
When you're, again, the word rejection means they've never accepted it, they just kicked it back. But if your EB2 to EB3 is denied, your EB2 remains intact. Nothing happens to it. So you can, let's say the EB2 now is progressing rampantly and you feel, you know what, I can file for my adjustment of status under EB2 dates of filing. I'm better off. You can still go back because nothing has happened to your EB2. It remains intact.
Wonderful. So while we line up one last question, I'll ask my own personal question here. I'll try to interject that. So I've been on EAD for last 8 years, I think. And since then, numerous times I've been filing them for renewals. And every time I file for renewal, there is that 6-month period, and then there is a 6-month automatic extension that we get. Question really is it pretty safe to travel while your EAD and AP is pending renewal? As I said, the context is a lot of people are getting those EADs in next few months, so they need to be aware of what they're getting into, just like what I have currently.
Absolutely. Again, as I mentioned earlier, Vijay, if somebody files for any application, be it an EAD extension, green card extension, H4 extension, if you leave the country, you've abandoned your application. That's what the USCIS will interpret it, that you have intentionally abandoned your application.
So there's a good restriction on in terms of when you can travel, especially when they're trying to use the EAD benefit, right?
Correct. And especially if you have an emergency, you need to travel, I would definitely get an info pass. And info passes are not easy anymore. It's very difficult, but if you truly have an emergency, you can go to a tier 1, tier 2 officer, explain, they'll give you an info pass. You can get to advance parole from the local office.
Okay, so there is one more question from our Facebook channel. This is more towards, okay, my spouse is on H4 EAD currently, and if we get our GC EADs because of the application that just went in, and we start using those GC EADs, what happens to this H4 EAD? Is there will it get automatically transitioned, or is there a thing?
No.
Okay.
It will not. And when you're filling up the application for the I-765, Vijay, Hemant, you all must have noticed that the H4 EAD has a certain section number. It is C33 or C26, something like this, okay? Whereas for an adjustment of status, your section is C9. So when they issue the card, you have that section number on the card. So they're going to be two different EADs, and you're entitled to both of them.
Okay. So I guess plenty of questions in the queue there. We want to basically respect everyone's times here. At the same time, Uma, do you want to present quickly what you got out there?
Very, very quickly, I just wanted to run
So
through some of the.
Hemant, you got the presentation, or
Yeah. Do you want me to go ahead and share the
yeah,
presentation?
share
Hold
that
on one
quickly,
second.
and then she can go over
I don't
quickly.
want to go through in detail because we've already discussed most of it.
Yeah. So if you can outline quickly, so you got next 5 minutes, and then we'll
Sure.
do a closing remark, and then that's it. We are done for tonight.
One of the things that I rampantly notice and hear is again comparisons. My friend got his H1 in one day. Why is mine taking 3 months? So don't compare. Everyone's case is different. Everyone's documentation is different. The adjudication officer is different. Even though they have standard operating procedures, some may apply it this way, some may apply it differently. So once you have that comparative thought process in your mind, you're going to burn yourself. So my advice is please don't do that. No matter what, your application is your application.
That's a very good point.
Secondly, if you're wanting to do do something in immigration, whether it's a family based, whether it's a employment based, whether it's an H1, L1, anything. If when in doubt, don't go to WhatsApp groups and get answers, because you're going to get only a quarter of an answer, because I'm not trying to insult people in any WhatsApp groups, but they have half a knowledge and they're passing quarter of a knowledge to you. So what's going to happen is you're going to make mistakes. It's like me going to WebMD and trying to treat myself as, I'm not a doctor. I'm not licensed. I don't know the ins and outs. I would rather have a doctor look at me to tell me what is wrong with me.
Yeah.
So similarly, for an attorney, consult. I'm not saying spend thousands. Spend a little money. That money is your investment on your life. Spend that money, find out the details, and then you make informed decisions. That is one advice I would highly, highly recommend everybody to do that. Doesn't matter which attorney you want to go to. One-on-one consultation will give you a lot of information, will tell you what to do, rather than these group discussions and comparisons.
All right. Let's quickly skim through the slides.
Sure. And again, we've gone through all of this. The rush to downgrade, there is still a lot of people who have not filed the EB2 to EB3 downgrade who've been contemplating. So if you want to do it, this is your month. And like I said, when opportunity knocks, don't give it up. Do it right away. You never know when the opportunity will actually knock again. So we'll go to the last few slides, where I've got one that is a comparison. This is what I wanted people to see, where, if there's been any movement between the October and the November bulletin. And as you all can see, there's not a whole lot of difference. But please be patient. Hopefully, we'll see better movement in December 2020 and Jan 2021. So we'll go to the last few slides. And we're talking about the H1B interim final rule, which is what has been introduced, and waiting on the 60-day rule, where they're going to be defining what is a specialty occupation, employer-employee relationship, and the limited petition validity that is going to be only for 1 year if you're placed at a third-party location. Of course, all this is going to be litigated, and we will see the effects of what the outcome is going to be pretty soon. And I definitely assure NATS and all its listeners, members, that if I get any information, I'll be the first one to pass it on to you all, so you can post it on the website for people to know what was the outcome of any of these court decisions.
Thank you.
We appreciate it.
So, I mean, there's so much to talk, whether it's about perms or the interim final rule, the lottery system, which is going to be revamped again based on the wage determination. I think there's a lot more to talk about H1s, and whenever NATS is willing to do another webinar, you have my word that I will come back and do the webinar.
Sure. Thank you.
And for those of you who need to reach out to me, you can always go to my website, which is very simple, mantralaw.com. I do a side profession of, doing the abracadabra. No, I'm just kidding. So,
It's in the name.
please reach out to me. I also do a radio show every Saturday in Houston on 106.1 FM. It's a completely interactive immigration talk show. We only do Q&As. Every Saturday I do this, and I talk in Hindi, Urdu, Telugu. I speak Tamil. I speak Gujarati. So pretty much I cover a lot of languages.
Yeah, I saw one of those on the Facebook. You got a pretty nice setting showing the Houston background there.
Correct.
Yeah.
So thank you all, and I hope I was able to answer at least most of the questions. And if we could not, it was due to the time factor, and I hope you all understand. Thank you very much, Hemant Garu, Vijay,
Thank you.
everybody
Thank
on
you,
the
madam.
executive committee for committing to do this webinar on a Friday night.
Yeah. Thank you, ma'am.
So yeah,
Thank you very much.
I guess it was our pleasure to host Uma Garu on a Friday night. Thanks to our dedication, service, and to the community. And NATS Houston, inspired by NATS national team, we did several seminars like this. We're continuing the series here, doing this webinar, giving up-to-date immigration-related information. And thanks everyone for watching this, and stay tuned. There will be more such webinars will be coming in, and you can contact any one of us personally, or we have natsworld.org, our website, and Houston, if you want to join, there's a WhatsApp group for Houston, and also there is a NATS helpline. There are various ways, Facebook page, there are multiple channels that you can contact us. If you want to specifically send some questions, immigration related, to get answered, natshoustontexas@gmail.com. We can follow up with Uma Garu for anybody that we might have missed today. It's a 2-hour plus session. I really appreciate all the dedication and the patience, especially Uma Garu at this late hour, to be with us and answering these questions, especially in a pretty turbulent environment that we got with this immigration. So that's it from the moderator here. Have a good night. Have a great weekend. Hemant, do you want to close anything?
Pretty much you covered everything, Vijay, and thank you from my side to Magaru. And
Thank you.
sure.
Thank you very much, and all of you have a lovely weekend.
Yeah.
You too,
Thank you.
Thank you. Bye-bye.
Bye.
Do you know how to stop this live?
I think she left, right?
Yeah, she left. Do we know how to stop the live feedcast?
I think you have to leave, I guess.
మీరు అక్కడ రెడ్ బటన్ నొక్కండి, రెడ్
అంటే నేను రెడ్ కొడితే నేను డిస్కనెక్ట్ అవుతాను, లైవ్ కూడా అయిపోతుందండి.
అవును. మీ లైవ్ ఆగిపోయిందండి. లైవ్ ఆపేసాము. మీరు ఇది డిస్కనెక్ట్.
ఓకే. వండర్‌ఫుల్. థాంక్ యూ వెరీ మచ్ అండి. మీకు కూడా మీకు లేట్ అయ్యి ఉంటుంది.
వెల్కమ్.
యాహ్!
నో
థాంక్ యూ.
ప్రాబ్లమ్. నో
ఇట్ వాస్
ప్రాబ్లమ్.
వెరీ
థాంక్
స్మూత్ ఎక్స్‌పీరియన్స్. నో ట్రబుల్ అట్ ఆల్. థాంక్ యూ.
యూ. ఓకేనండి. థాంక్ యూ.
థ్యాంక్ యూ. థ్యాంక్ యూ.
గుడ్ నైట్.
అందుకే తెలివి ఉన్న తెలుగువాడు దీన్ని చక్కగా వినియోగించుకున్నాడు, అవకాశాలను అందిపుచ్చుకున్నాడు. అనుకున్నది సాధించడంలో, ఉన్నత శిఖరాలను చేరుకోవడంలోనూ సత్తా చాటుతున్నాడు. మరి ఇంత పెద్ద దేశంలో జరగరానిది జరిగితే, అనుకోనిది సంభవిస్తే అప్పుడు ఏం చేయాలి? ఎవరి తలుపు తట్టాలి? ఆ ఆపద సమయంలో ఎవరు అండగా నిలబడతారు? ఇలాంటి ప్రశ్నలన్నింటికీ ఒకే ఒక్క సమాధానం. ఉత్తర అమెరికా తెలుగు సంఘం నాట్స్